All right, good morning, everyone. This meeting is called to order. Do want to welcome our newest commissioner, Albert Trevino. Commissioner, welcome.
Thank you, sir.
Thank you very much. All right, let's jump into the agenda. Mr. Truman, has anyone signed up for public comment?
Yes, sir.
Good morning, Ms. Miller.
Good morning, sir.
All right, no cases reconsidered under agenda item 3.
That is correct.
How about tax liability cases under agenda item 4? I think there's 4 cases on this docket.
I'm showing 2 cases, sir.
You know, the truth is I can't read because it said agenda item 4 and then it said 2 cases. I should read the whole sentence.
Thank you, sir. All right, the first case is case number TD 22-033-0922. Commissioner Demerson,
Agree with staff's recommendation.
Commissioner Trevino,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation.
The second case is TD 22-039-1022. Commissioner Demerson,
Agree with staff recommendation.
Commissioner Trevino,
I agree with staff's recommendation.
And
Agree
Mr.
with staff
Chairman.
recommendation.
thank you, gentlemen.
We have no fair housing cases under agenda item 5.
There are none.
Under agenda item 6, we have no wage claim cases on docket 50 pulled for additional discussion.
None pulled for additional discussion, but you should have received the wage claim short form descent list for docket 50.
I move we accept staff recommendations on the remaining wage claim cases on docket 50.
And Commissioner Demerson, I believe you're next.
Okay, I concur with the chairman's motion, except for the cases on which I'm dissenting is reflected in the wage claim short form dissent list, docket 50. I concur with chairman's motion, except for those cases on which I dissenting as reflected on wage claim short form dissent list, docket 50.
Thank you.
Motion passes with the exceptions noted.
Yes, sir.
Let's move to agenda item 7 and consideration of unemployment insurance cases on docket 50. Please proceed when you're ready.
Case number 2470575, Commissioner Trevino.
The AT decision should be modified. I do not dispute that the claimant did not establish good cause for the non-appearance at the AT1 hearing. However, based on the available evidence, the claimant's work separation was due to a medically verifiable illness of his minor child. The claimant was discharged for excessive absenteeism. His absences resulted when he had to leave to attend emergencies regarding his special needs 13-year-old child at school. The claimant's work separation was caused by a medically verifiable illness of his minor child, and his discharge was for reasons that did not constitute misconduct connected with the work. Modify the AT. No good cause for the non-appearance at the AT. 1, and no misconduct, no chargeback due to MVI. We should affirm the appeal tribunal decision concerning good cause. Although the claimant received the AT1 hearing notice, he failed to attend the hearing because he did not read the notice nor pay attention to the hearing date. As the claimant was not prevented from participating in the hearing due to circumstances beyond his control, he did not establish good cause. Concerning the job separation, the claimant was on final warning for his absences and was aware that further attendance violations could result in termination of employment. The claimant was terminated when he continued to be tardy and/or absent from work. Since the claimant was on final warning with the employer, but thereafter continued to violate the employer's attendance rules, the claimant mismanaged his position of employment. Hence, we should affirm the AT decision. The claimant did not have good cause for missing the AT1 hearing. Misconduct, no chargeback.
Affirm the AT. Claimant did not establish good cause for AT1. Misconduct, no chargeback.
Short form dissent.
Yes, sir.
Case number 2799632, Commissioner Trevino.
The AT decision is not supportable. The claimant was separated from the employer on December 21st, 2020, when her assignment ended due to no fault on her part. At that time, the employer failed to offer her further work, and she filed a valid initial claim. After her employment ended, the claimant moved from Houston, Texas to Cleveland, Texas. On January 13th, 2021, the employer offered the claimant a new assignment, which was located near her previous assignment for 25 hours per week with a 10% pay reduction. However, since the claimant had moved while she was unemployed, the new assignment was approximately 46 miles from her new residence and would require about an hour commute each way for only 3-4 hours of work, 7 days a week. While the claimant provided the employer her new address, they did not offer any work in her new area. As a new assignment would require the claimant to commute an excessive distance each day for only a few hours of work, the claimant had good cause to refuse the assignment. The AT decision should be reversed. No offer of suitable work, no overpayment.
The appeal tribunal decision should be affirmed. The claimant was offered suitable work that was the distance from where she resides. However, such distance was the result of the claimant's own doing since she had moved. Moreover, according to a fact-finding statement provided by the employer, the claimant had refused to provide the employer with her address and had not updated her address. Accordingly, the claimant refused an offer of suitable work without good cause, and we should affirm the AT decision. Suitable work disqualification, overpayment.
Reverse the AT, no suitable work disqualification, no overpayment, memo to investigate availability.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 2803519, Commissioner Demerson.
We should modify the appeal tribunal decision. First, I do not dispute that the claimant's appeal to the initial determination was timely. Concerning the job separation, the employer required its employees to consult with the general manager for any workplace-related concerns. The claimant quit when she engaged in an altercation with the front desk manager about the conduct of a coworker. During the altercation, the claimant became belligerent and abandoned her job. Since the record suggests that the claimant was aware of the employer's procedures for reporting workplace-related concerns, but thereafter quit without using proper channels to address her concerns or providing the employer with an opportunity to address her needs, the claimant quit without good cause connected with the work. Hence, we should modify the AT decision, timely claimant appeal, voluntary leaving, no chargeback.
The AT decision is not supportable. The envelope in which the claimant's appeal was mailed has not been located. Under commission rule, the appeal date in this situation is 3 business days prior to the date of receipt. The appeal is stamped as received on September 15th, 2020. 3 business days prior to the date is September 10th, 2020, which is within the appeal period. On the separation, the claimants resigned when she was harassed by a co-owner after the claimant complained about that co-owner's use of a racial slur. The claimant quit in response to the egregious workplace conditions and therefore with good cause connected with the work. Reverse the AT, timely appeal to the AT, no voluntary hearing chargeback.
Modify the AT, timely claim and appeal, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir.
Case number 2872673, Commissioner Trevino.
The decision is not supportable. The claimant filed a claim for reduced hours due to the pandemic. The reported earnings show that the claimant experienced reduced hours and was partially unemployed during the initial weeks of the claim. Reverse the AT, valid claim, no overpayment.
The appeal tribunal decision should be affirmed. Commission records reflect that the claimant was neither totally unemployed nor partially unemployed when she filed her initial claim. Consequently, the claimant did not file a valid claim and the associated overpayment is appropriate. We should therefore affirm the AT decision. The claimant did not file a valid claim, overpayment.
Reverse the AT, valid claim, no overpayment.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 2973529, Commissioner Trevino.
I agree that the AT1 and AT2 decisions should be set aside and that the October 5th, 2020 determination should be voided. Additionally, I agree that the claimant had no reasonable assurance of further work with the employer and that the employer's appeal to the September 8th, 2020 determination should be deemed timely. Regarding the separation, the employer admitted that the claimant was off work on unpaid FMLA leave. when he filed his initial claim in August of 2020. As the claimant's separation was due to his medically verifiable illness, the claimant had good cause connected with the work for quitting. Set aside AT1 and AT2 decisions, void the 10-5-20 determination, reinstate the 9-8-20 determination, timely employer appeal, no voluntary leaving, bill reimbursing employer, void adequate response.
First, I agree that the AT1 and AT2 decisions should be set aside, that the October 5th, 2020 determinations should be voided, and the September 8th, 2020 job separation determination should be reinstated, and that the claimant did not have reasonable assurance. Also agree that the employer filed a timely appeal based on non-receipt of the determination. Concerning the merits, the claimant has provided inconsistent statements to explain why he stopped working in July 2020. First told TWC he was self-quarantining due to COVID symptoms, then testified at the hearing that he was scheduled for eye surgeries. Because the claimant did not provide any medical documentation advising him to stop working, the claimant is considered to have quit without good cause connected with the work. We should therefore, again, set aside the AT1 and AT2 decisions, void the October 5th, 2020 determination, and reinstate the September 8th, 2020 determination, timely employer appeal, voluntary leaving, reimbursing employer not billed, adequate employer response. The claimant did not have reasonable assurance. In addition, we should send a memo to investigate unreported earnings and to determine whether a continued claim based on the December 2020 job separation should be processed.
Set aside AT1 and AT2 with regard to good cause, separation, reimbursement, and adequate response. Void the October 5th, 2020 separation determination. Reinstate the September 8th, 2020 determination. Timely employer appeal, no misconduct, bill reimbursing employer. Claimant did not have reasonable assurance. Memo in accordance with staff recommendation. In addition, investigate the claimant's ability to work.
Could you please clarify your vote on the separation?
No misconduct.
No misconduct. Okay. We have a majority vote that the claimant should be paid benefits, but the rationale is different. So the chairman has said no misconduct, which is a particular section of law, and your vote was no voluntary leaving, which is a different section of law. So we'll need to have one in which to write the decision with.
We'll go with the commissioner's recommendation.
Very well. The majority vote is no misconduct. The votes of all three commissioners were the same on all of the confusing issues. So the separation issue is no misconduct, reimbursing employer billed, and then there was no reasonable assurance, plus the memos.
The chairman, a short form dissent on the job separation.
I have your short form dissent on the separation. Did I cover everything, gentlemen? I believe I have.
Yeah.
Thank you.
Thank you.
Case number 3016968, Commissioner Trevino.
The AT decision should be reversed. Texas Workforce Commission Rules 815.32B and 815.32C provide that a document mailed to a party is presumed to be received if the document was mailed to the complete correct address of record. However, mailing a notice to a party representative, whether or not an attorney, is required to bind parties to timeliness rules. The hearing officer for the AT1 hearing was on notice that the claimant had an attorney and therefore that the AT1 decision should be mailed to his attorney per Commission Rule 32C. Since the AT1 decision was not mailed to the claimant's attorney, the claimant was not bound by the timeliness rules. Reverse the AT2 decision, timely petition to reopen and remand for merits testimony.
We should affirm the appeal tribunal decision. Despite some inconsistencies in testimony, it appears that the claimant received the AT1 decision and provided a copy to his attorney prior to the appeal deadline. As to why the appeal was filed late, the evidence is a bit unclear. The claimant's attorney testified that he filed a late appeal due to illness. The claimant testified that he did not have his attorney represent him on this claim until after the appeal deadline had passed. Under either scenario, because there is no good cause exception to the timeliness rules, the claimant's appeal is late, and we do not have jurisdiction to consider the underlying merits. Accordingly, we should affirm the AT decision. The claimant filed a late Rule 16 petition to reopen, voluntary leaving, tax governmental employer, ability not eligible beginning July 5th, 2020, an overpayment of $9,378.
Affirm the AT. Claimant filed an untimely petition to reopen. Voluntary leaving, tax governmental employer, claimant not able to work beginning July 5th, 2020, overpayment.
Short form dissent.
Yes, sir. Commissioner Trevino.
Thank you.
Case number 3052643, Commissioner Demerson.
We should modify the appeal tribunal decision. First, I do not contest the validity of claim issue. Concerning the job separation, prior to the governor's executive order on vaccines, the employer implemented the vaccination rule, which required employees to submit a religious or medical exemption for refusing the vaccine. The employer credibly testified that the claimant did not submit an exemption and thereafter stopped working for the employer on September 27, 2021. As such, since the claimant failed to comply with the requisite rule in the allowed time frame, the claimant was discharged under disqualifying circumstances. Hence, we should modify the AT decision. Valid initial claim, misconduct, reimbursing employer not billed, adequate employer response.
The decision is correct. The claimant was discharged for failing to comply with the employer's COVID-19 vaccine mandate. The employer only offered exemptions for medical or religious reasons. The employer failed to offer an exemption for reasons of personal conscience. As such, the claimant's discharge was for reasons other than misconduct connected with the work. Affirm the AT, valid claim, no misconduct, bill, reimbursing employer.
Modify the AT. Valid claim, misconduct, reimbursing employer not billed, adequate employer response.
Short form dissent.
Yes, sir.
Case number 3069269, Commissioner Demerson.
The AG decision is not supportable based on the evidence currently available. The chargeback notice was mailed out during May 2020 when the pandemic was still in full force and effect and was causing TWC and postal systems to be overwhelmed. Although the testimony from the employer's witnesses did not address the specific notice in this particular case, the owner mentioned that she should have submitted a spreadsheet identifying all of the employees who had been laid off due to COVID-19. If that spreadsheet was submitted to TWC in a timely manner, and if it included the name of the claimant in this case, it should have been considered a timely response to the NMPC. There's no further information concerning that spreadsheet in the file. Accordingly, we should hold a rehearing for additional evidence from the employer concerning the spreadsheet submitted by the employer, specifically covering the questions of whether it was submitted to TWC, when it was submitted, and whether it named the claimant as one of the employees whose layoff resulted from the pandemic.
The decision is correct. The employer signed up for electronic correspondence, received the notice of maximum potential chargeback, and failed to respond. The employer provided no justification for their failure to respond. Affirm the AT. Employer response to the notice of maximum potential chargeback not timely.
Reverse the AT. Timely response to the NMPC. Resubmit.
The case will be resubmitted. There's only one vote for a rehearing. Did you want a rehearing or no, sir? Commissioner Demerson had voted for a rehearing.
But the case will be resubmitted.
With or without, depending on your choice. Without a rehearing. We need 2 votes to rehear the case. We'll resubmit it regardless. Actually, that's correct. Okay. Let me clarify. Commissioner Dimerson did not vote that it was timely and to rehear. He voted merely to rehear from the start. Chairman Daniel, your vote was timely and resubmit on the merits. And then Commissioner Trevino, you voted that it was not timely. So it is correct. There is not yet a majority on the timeliness issue.
We'd like a rehearing, but that's okay. We'll go with the chairman's vote.
So the majority vote for Commissioner Dimerson and the chairman is timely response and resubmit on the merits.
Yeah.
Okay, and there's no dissenting at this point because the case will be resubmitted. So
Okay, so no short form consent.
you could state one, it wouldn't hurt anything, but
Okay.
there's not going to be a decision issued in order to document a dissent on it. It's going to come back to you for another vote.
Okay, Ms. Miller, I'll short form dissent right now, Chaser.
Okay,
Thank you.
thank you.
Case number 3276743, Commissioner Trevino.
The AT decision should be modified. I agree that the claimant filed a valid claim. However, the claimant has denied under oath that the allegations of using inappropriate language towards a coworker. The employer has a burden to prove misconduct, which they failed to do so in this case. The employer's exclusively secondhand hearsay statements are insufficient to overcome the claimant's sworn denial. The claimant was discharged for reasons other than misconduct connected with the work. Modify the AT decision, valid claim, no misconduct, chargeback.
We should affirm the appeal tribunal decision. The numerous written statements provided by both the employer and the claimant established that the claimant used profanity during an interaction with coworkers. Although the claimant tried to minimize and explain away his admitted use of profanity, the weight of the most credible evidence, which is sufficient to overcome the claimant's denial, established that the claimant mismanaged his position of employment. We should affirm the AT decision. The claimant filed a valid claim, misconduct, no chargeback.
Modify the AT valid claim, no misconduct, chargeback.
Short form dissent.
Yes, sir. And that was the last unemployment insurance case pulled for additional discussion on docket 50. You should have received the UI wage claim short form dissent list for docket 50.
I move we accept staff recommendations on the remaining UI cases on docket 50.
All right, the chairman's motion, except for the cases on which I'm dissenting, is reflected in the UI short form dissent list for docket 50.
I concur with the chairman's motion, except for those cases on which I am dissenting, as reflected on the UI short form dissent list for docket 50.
Motion passes with the exceptions noted.
Thank you very much.
Thank you. Let's take a short recess. All right, we're back with agenda item 8. This is a UI trust fund update.
Good morning, Chairman Daniel, Commissioner Dimerson, Commissioner Trevino. Mr. Cerna, for the record, Chris Nelson, Chief Financial Officer. This morning, you have before you the current trust fund projection, unemployment insurance trust fund projection as of September, that would be in effect of September 30th, 2023. And there's three parts. I'll walk through it, and in deference to Commissioner Trevino, I'll try to limit my use of acronyms or spell them out when I do. There's three parts to this projection. The section 1 basically walks through the current, the beginning balance and the estimated ending balance as of September 30th. Section 2 walks through that relation of the balance to the unemployment floor, which is 1% of taxable wages. And section 3 walks through the status of the employment and training investment account, Fund 5128. So we started the year October 1st, 2022, with a $2.154 billion balance in the trust fund. We're projecting remittances or revenue of a little over $2 billion. If you look to the same row, column 22, you'll see it was 2.6 billion. That reflects, if you remember, the commission back this summer took action on non-last employing units to allow additional appeals activity. That reduction in revenue is reflected by that action. That's our current estimate. It's probably about a $650 million reduction in revenue based off the information we have from the appeals staff as of today. We still project about 2.1 billion in benefits paid on 1.09, leaving a balance of 2.1 billion. So even with a non-last employing unit action, it looks like if you go down to section 2, we're projecting we'll still be above the floor as of September 30th. So, which is a good thing. And in the next update on section 2.01, we'll probably have an update to the floor. That number is probably going to be closer to 1.2, 1.3 billion versus the 1.146 I'm reflecting here. But even with that increase in the floor, we'll still be above the floor with the projected balances based on what we see so far. The employment and training investment account is the 1/10 of a percent that's put into this fund 5128, and it really serves two purposes. One is when the when the trust fund is above the floor, it's used to fund basically the skills appropriation. When we're below the floor, which we're not projecting to be, you're supposed to transfer the amount into the unemployment insurance trust fund to the point that you bring the fund back above the floor, that you basically deplete the 5128 account. So right now, if you look on section 3.04, that 39.8 million, that reflects, so we were above the floor October 1st, 2022. So that reflects basically the transfer we did to fund the 2023 skills appropriation of about 19.8 million, and projects us funding the 2024 skills appropriation, which would be another 19.8 billion this coming September. It's because the transfer didn't happen until after October 1st of last year for 23. That's why it's shown in the 23 column, but it's really two appropriation years for the skills funds that would be appropriated. And it doesn't increase the skills appropriation. It basically just funds it, and then the GR goes back to the controller's office. That kind of concludes my presentations, and I'd be happy to answer any questions.
Any questions or comments?
Because you said 20 million, right?
Yes, the skills appro.
Yeah.
Yeah. Yes, the net does not include JET. It's just the skills appropriation that's laid out in statute. So it's about 19.8 million per year.
I keep hearing that billion. It's 20
Huh?
million.
Oh,
Million.
million.
Yeah, million.
Yes,
Okay.
yes, not billion.
It's hard to know with him. He gives.
That'd be a
like,
big
large
exceptional
ranges
item.
of numbers.
Be a big exceptional item to get it to B.
Just M's today, no B's.
Yes,
There's some B's in here.
Say again.
There's some billions.
Oh, yes,
Are there any
yes,
trillions?
yes. No.
Not yet. All right.
Nothing else.
All right.
Nothing else.
Thank you.
Thank you.
All right, let's see here. On agenda items 9 through 12, which are standing agenda items, but I don't think we have anything for any of those today. All right. Is there a legislative report today? I think your speculation was correct, Commissioner.
All right.
Is there an executive director's report today? Yeah. The time is now 9:32. The Texas Workforce Commission is going into executive session, room 250B, to discuss the appointment, employment evaluation, reassignment duties, discipline or dismissal of the executive director, internal auditor, executive staff, or other personnel pursuant to Texas Government Code, section 551007 4A1. Well, the executive session has concluded. The time is 9:43. All right. Is there any other order of business to come before the commission?
Commissioner, I want to officially welcome Commissioner Trevino on board. Delighted to have you here and congratulations on completing your first docket as well and almost your first commission meeting, but welcome aboard.
Thank you so much.
No other from me.
Nothing? Do you have anything you'd like to share?
No, I just want to thank Chairman Daniel, Commissioner Demerson, and the staff here at Texas Workforce Commission for welcoming me into their arms, and it's been very enlightening and eye-opening, and I'm very pleased to be here. It's a great workforce, and I'm very happy and proud to have been appointed to this position, and hopefully I'll do my best, and I know I will with everybody that's here behind me. Thank you.
Thank you. Commissioner, I can already see your just how much influence you're going to have. There's staff people here at this meeting I haven't seen in months. That's pretty influential, and not just Lowell. I mean, there's a lot of other staff people out there. No, welcome.
Thank you.
Thank you. Good meeting. We didn't set any records this time, but
No.
I thought we had a solid meeting. We got through a lot of business. If you would, I hope you're able. I hope everyone's able. We've put together just a small little welcoming reception, and I call it the green room. It's the room next door here to welcome Commissioner Trevino. Please join us there immediately following this meeting. If there's no other business, we would need a motion to adjourn.
So moved.
It's been moved
I second the motion to adjourn.
and seconded, and we're adjourned. Thank you.
Thank you.